Thank you, Chair. Dr. Igartua, clearly the members of your association have very serious concerns with regard to the legalization of cannabis. And in your presentation, you made 10 recommendations, and I have to say that I fully agree with all 10 of them. Now, that being said, I must speak advisedly because I chaired for 25 years in New Brunswick, the review association with regard to people who are found mentally unfit because of mental health problems. I have to say that most of the cases we heard had to do with consumption of drugs, especially marijuana. And so my question is as follows. In your brief, you mentioned the experiences of Colorado and Washington. And I understand that in those states, the legalization of cannabis created a type of normalization and a greater availability and use of cannabis, especially among minors. And in the wake of that, recommendation number 9, where you urge the parties to carry out advertising campaigns seeking to denormalize all of that. Could you please elaborate on that? Yes. In the same way that alcohol is illegal for people age 18 and under, that doesn't matter because teenagers drink alcohol. Now, perhaps less now than in the past, but they certainly can get a hold of it because it's not even the black market. They don't go and get it from bootleg. It's just someone goes to the LCBO and buys it for them. So I can imagine the same thing it will happen with cannabis, whether we're talking about 18, 19, or 21 years of age. It's the same thing. Young people will get a hold of it, probably on the illegal market, probably illicitly. So young people need to be aware of the risks that they are taking, and they need to know how to reduce those risks. So it's better for a young person to smoke in their basement at home than out in the streets where there's no one to supervise them. We would prefer that they smoke once a month instead of once a day. We would prefer that they smoke a joint that has lower levels of THC, for example. So that's a way of reducing risks. But people need to understand that smoking cannabis is like Russian roulette. It could trigger a psychotic incident, and we won't know because right now there are some 220 genes in the human body, and we're trying to understand what the interaction is. So to understand who is at risk of psychosis and who is not. The science has not progressed to that stage where we can identify for whom it's dangerous and whom it's not. For every young person who smokes a joint, it's like Russian roulette, and they need to know that, especially if there is psychosis in that young person's family, the risk is higher. You talked about that your review board, and that clearly illustrates the fact that the prognosis for psychosis is worse among people who continue to smoke than those who stop smoking, and that's probably why you have seen so many people who had consumption problems, because people who have psychosis and don't consume cannabis, they have a better prognosis, and they're not as often found non-criminally responsible. Senator Kangya, please go ahead. This is really fascinating. I just understood why I have an accent when I speak English. My question goes to Mr. Thibodeau. You touched on this, and this is something that I've raised before too. The last time we met, you were with one of the most renowned class action experts in Canada. Oh yes, that's the preface of my book, as a matter of fact. So, could you please elaborate? Because you feel that there's a risk of class action lawsuits, like we saw in tobacco, if the information is not detailed enough with regard to prevention regarding the obligation to inform. And as we see that there are risks that are still unknown and that are difficult to determine the impact. Senator Carignan, you've taken the words right out of my mouth, and I think that we're seeing this. That's what happened with the class action lawsuit and the tobacco companies. And I'm happy to hear my lawyer colleagues and the Psychiatrists Association. We can't wait until people, we can't wait until it's too late to inform people. We have to tell them ahead of time. So I'm just a lawyer. And there are studies that have been done, but it's clear that there are risks. And what we're criticizing the government for, and tobacco companies as well, and I think that we need to take preventive measures by informing people. So, because we're talking about class action suits, to ensure that, whether it be in 2 years or 5 years or 10 years, when we discovered that there are risks and even dangers, and why not? The producers may be blamed, and the producers, I'm sure, are conducting studies, and so are distributors. I don't know, Dr. Galtois, if you've seen that, but what are going to be the strengths and weaknesses? There's going to be an industry around the marketing of cannabis, just like there is for alcohol, and that'll be the same. It's the same thing for gambling. The government was sued because some of the slot machines are in places where alcohol is sold. So I think you're absolutely right, and everything that I'm hearing today confirms that regarding class actions. Very quickly, Senator, please. For the members of the bar, this is my question. Obviously, I'm a member of the bar of the Quebec Bar, and I always follow very closely your positions. On March 2nd, 2018, the bar presented a brief on C46, which raised the problem of the per se limits. And it says, upon reading Bill C46 regarding the concentration of drugs in the blood, it goes beyond what is necessary to achieve the legitimate objective of prevention and ensuring road safety. Whereas scientists say that very little research has been done with regard to the effect of drugs on driving. And as proposed, the regulation criminalizes the level of drugs in the blood for which scientific proof brings about, in our opinion, we need better scientific evidence, and therefore the legislation proposed in terms of drug-impaired driving with a prohibited level of drugs will absolutely come before the courts. So you seem to say that it's not good to have per se limits. And then on April 18th, 2018, you said it would be important to establish a per se limit to facilitate the enforcement of the law and the demonstration of drug-impaired driving. Now, I understand that this is the opinion of the bar, and perhaps two different committees studied it, but we're hearing from the bar, and I see a contradiction there. Would you be able to clarify that for us? Mr. Legrand-Allary, with regard to C46, which that included comments on the draft regulations as well, and that targets cases where there were per se limits that were put in place, targeting a cocktail of alcohol and different drugs. With regard to the brief that we're submitting today, we're talking about the concentration of THC where there is more reliable data. Even per se limits facilitate the charges and convictions of people who have committed offences. However, in Bill C-46 and in the criminal code, there is still a charge of drug-impaired driving that has to do with evaluation of the abilities of the driver. So we need more reliable data concerning this cocktail of drugs, aside from alcohol and cannabis, because that is only when we can measure the faculties of the driver. Thank you, Chair. My question goes to the Quebec Bar, and it concerns the interaction between the provincial legislation and federal legislation. I'd just like to say that unlike what was given to understand, it will be illegal under provincial laws for minors aged between 12 and 17 to possess cannabis across Canada. You did not address, you and the Quebec Bar, you did not address in your brief or in your presentation the matter which is specific to Quebec and Manitoba. And it's very important, and we're talking about growing marijuana at home, because there will be two different systems, and for people in Quebec it'll be very confusing. Now, we're used to having confusing situations in Quebec, but we've got this provincial law that says that it is prohibited to have cannabis plants at home, and the federal law says that that they can have up to 4 plants at home. So that is perhaps something that you don't want to speak out on right now. But which is going to be paramount, the federal law or the provincial law? How is that going to be decided, and what is your opinion on that? Indeed, the federal paramountcy doctrine is a principle that exists and that was recognized by the Supreme Court, and it's in the Constitution. There have been certain cases that were highly mediatized, and we've seen rulings on that. We in the Quebec Bar, we do not think that it is the role of the Quebec Bar to issue a legal opinion on these kind of controversial issues. But we can say that it is a problem, an issue that should be discussed before the courts, and so we'd like to draw attention to both the federal and provincial legislators, draw their attention to that there could be a conflict. We don't want to take a position. It's a problem, a legitimate legal problem that could end up before the courts, and we want just to underscore that. Now, the Quebec Bar also said that there's potential for conflict, and the National Assembly asked us to speak out on that as well, to issue an opinion. But we are not judges. Judges tend to presume that there is going to be a conflict, and insofar as possible, they try to avoid this conflict, and if such a conflict crops up, well, we don't know what direction they're going to go in. So it's difficult for us. It can depend on the facts, the circumstances, and it can even depend on the judge. I had a second question, very quick, Chair, because and I want to ask Dr. Igartsua. You talked about THC limits in the draft regulations that were put forward by the government. For certain products, there are THC limits, but that does not exist for dried cannabis because there's a type of natural limit, which is around 30%. But you came up with a recommendation of 15%, and then half of that, about 8%, for younger consumers under the age of 21. What facts do you base yourself upon? Is there something that says that these levels are less dangerous? Well, it's difficult to answer because there are no specific data that says at a certain level of THC it's no longer dangerous. The principle is that the less THC, the less dangerous it is. We used figures from Colorado and in the Netherlands, where they tried to establish such a limit. And so we used those figures. Also, most of the cannabis that is on the illicit market right now is at around between 12 and 14%. So we thought if we said 15%, then we would cover the illicit market. And so that is why we chose that figure. But is there data that says that 15 is less dangerous than 16? No. You said earlier that there's a natural limit for dried cannabis, and I think you have to be very careful about that, because in 1994, cannabis was 4%, and in 2012 we were up at around 12 or 13%, and now, you know, the growers have tweaked things, and they're able to bring the content up to the potency up to 28, 30, 32%. So, you know, the growers will be able to work on the plants, to cultivate them. Just think of the shatter. I don't think you saw that. They've seen THC at levels of up to 80% in shatter. So growers they are able to maximize the content, and if we don't put guidelines out right now, then that will be a danger. Thank you, Senator Boniface.